Hello. Thank you for joining us for another episode of This Week in AML. I'm John Byrne, Chair of the AMLRS Advisory Board.
And I'm Elliot Berman, our Creative Director. We are excited to welcome you to the This Week in AML podcast,
where we explore key news and developments in the global financial crime prevention community.
Hi, John. How are you today?
I'm good, Elliot. How are you?
I'm good, too. We've had a couple of beautiful days here in the Midwest, and I've been learning about a bunch of new things. And today I thought, they're actually taking votes in the House on amendments to the Enablers Act, which we talked about a few weeks ago. Piece of legislation broadly speaking, extending the some of the provisions of the Bank Secrecy Act to lawyers, accountants, trusts, and others who are involved in financial transactions. It's been attached to the National Defense Authorization Act, so it's being actively looked at. And I know you were watching the live telecast of the vote. So what's going on with that?
Well, it's still going on, and it does tell you that this is why Congress is, how can we phrase it carefully, how they are unable to really do anything. If you remember how a bill becomes law, you can introduce a bill, go through committee, go to the floor, that kind of thing. While that still happens, it's only these major pieces of legislation like the NDAA that even allows sort of adjacent and sometimes not very clearly connected amendments to be included. So that's what's going on, and it's probably going to go all day. We're recording this on Thursday, but I thought it was important to highlight a bunch of things. Also, to just say to folks that are paying attention to these sort of activities, it's HR 7900 is the bill. So if you go to house.gov, you can certainly take a look at massive amounts of provisions. There's over 1,000 amendments, maybe even more. So it's hard to sort of navigate, but I thought there were a few things that we should at least highlight because some of these will make it through. This has to go through the Senate after the House, but like NDAA back in January of 2021 or late December 2020, more than likely, if it's in the House provisions, it'll stay in the Senate provisions. Obviously, depends on are there voice votes, are there roll calls, that kind of stuff. But there's a few things in there. There's a number of provisions, amendments rather, on corruption, anti-corruption offices to deal with that. That was in there. Also, the proverbial Safe Banking Act that we've seen that has been around for a number of years that would deal with the issue that many of our clients struggle with, and that is, given the fact that you're trying to decide whether you're going to bank marijuana businesses, and marijuana is still a Schedule 1 or Schedule A, whatever the category is, controlled substance. So this Safe Banking Act, which again has been around for a number of years, would give a safe harbor for institutions that decide to go ahead and bank, and obviously they'd have to do their proper due diligence. So that's in there. We had talked about domestic PEPs. That was considered out of order, so that amendment did not make it through. So whether it comes back up again in the Senate is still a question. But as we've mentioned before, domestic PEPs, some of our clients already screen for those, but many do not. And obviously this would add some requirements that they're not currently oversighted from the regulators. So we'll see what happens with that. But also a couple other ones that I thought were interesting. One would extend the statute of limitations for money laundering offenses, specifically for those that relate to oligarchs. So if you get an oligarch that's laundered money, you'd extend the statute of limitations so you'd have a longer period of time to prosecute. So that's obviously a reaction to what's going on in Ukraine. And similar to that is another amendment that any assets that are captured by from oligarchs would be designated to help rebuild Ukraine. So that's interesting. Again, like I said, a number of provisions on cyber. And then one I know that you've looked at and we've talked about, and that is the enablers provision that would include so-called gatekeepers that aren't currently required to deal with the requirements of the Bank Secrecy Act.
Yeah, and the important thing there, and again, you and I have talked about this in the past, is it was driven. Some of that was actually driven by the Pandora Papers about how gatekeepers have become the enablers, and in fact, even it's actually in the preamble to the actual legislation. They have become the enablers to help people move and hide assets, and while some of those people maybe are doing things that are perfectly legal, many of them are not, or it's a mixture of legal and illegal. And so and I think we talked about this as well, there are a number of other countries, the UK being one of them, where lawyers and accountants and corporate service companies already have some obligations, maybe not the full regimen that we have in the United States of the Bank Secrecy Act, but certainly have disclosure obligations, reporting obligations, that kind of thing. And my own opinion is that it's important for people who are engaged in those kinds of activities to be responsible for their acts, and in particular, as you and I are both lawyers, it's one thing to vigorously represent someone charged with a crime,
right,
in defending them, but I think it's another thing to be a facilitator or an enabler of people committing crimes or actively hiding the fruits of crime. That strikes me as out of bounds, and it's, I guess, the Pollyanna in me, and there isn't much of that, as you know, John, would say it's too bad that we actually have to have an act to require this stuff, because it seems like doing the right thing is what you're supposed to do. But if we need an act, then let's go get one.
Yeah, the reference point in the sort of the preamble to the coverage of gatekeepers includes, as you just said, references to the Pandora Papers and FATF, and also, I think we've talked about this, maybe even on this program, is back in last December, the U.S. had a strategy on countering corruption, and so in that strategy, they talk specifically about the deficiencies in our framework, including what they're trying to cover here: professionals and service providers and lawyers, accountants, trust company service providers, and others that help, quote, enable, unquote, the movement of illicit funds. So there's a lot of factual support for why this is being included. I think what's going to be interesting is the way the amendment is currently structured. So if it doesn't change, the requirements for gatekeepers would be obviously decided by the Treasury Department through regulation, or maybe obviously FinCEN. But the requirements, once that's decided, you're covered. What are going to be the appropriate requirements? So the regulation will say, obviously totally guessing here, it'll say if you're a lawyer and you're involved in these certain transactions, you need to do this. If you're a corporate service provider, you need to do that sort of thing. So
Right.
that's part of it. And then also, Treasury is going to have to identify people that are in these categories. So it's a lot to do if this is to happen, and it's going to be interesting to see if there's any opposition to this on the Senate side. Because right now, again, as we're recording, it looks pretty clear that this is going to make it through the House.
Yeah, that approach to the legislation extending the umbrella, if you will, of the Bank Secrecy Act to a new class of folks, and then leaving it to the FinCEN ultimately to write the regs. That's what happened with in the Patriot Act. That's how insurance providers got brought into the act. They were added to the list of organizations to be covered, but the actual detail, and that's why we ended up with some parts of the insurance industry being covered, comprehensively, and some not, based on FinCEN's determination through the process of where was the money laundering risk.
Right, and there's toward the end of the amendment, there's also a recognition that to make this effective, you're going to have to work with states and localities, and there actually is a provision that says the Treasury, and they always put this language in there, to the greatest extent practicable, will establish relationships with state, local, territorial, and tribal government agencies to figure all this out. So I think that's obviously a recognition that there's only so much you can do on the federal level. You're going to need some state support, because in many of these states, that's where the licensing requirements are, and that's the application process, that sort of thing. So it'll be, it's not going to be easy to do. It'll probably take a while, notwithstanding the deadlines, but I agree with you that this is something that should have been done quite a long period of time ago.
Indeed. So here's a chance for a shameless plug. What else do you have going on?
We have a couple of podcasts that we haven't posted yet. One with a former Federal Reserve employee that now works for CipherTrace and talks about crypto. That's coming up. And then a real interesting conversation with the new executive secretary of Wolfsburg. And so that'll get posted. I'm also working with the IRS to talk to some of their folks, updates with them on some of the work that they're doing. And then, I have a couple other potential folks to interview that I'm working on yet, but I'll save that for next week.
Okay. And I'll throw one in. If you look to our website, we posted a blog that I wrote. That's not why you should read it, but it's about the new crypto framework that is been preliminarily agreed to in the European Union, that will is being viewed as something that might be to crypto what GDPR is to privacy, in terms of leading the way of a functional framework for managing the consumer protection aspects and the operating environment for crypto asset service providers. So worthwhile to see that. It won't become law for probably another 18 months, but it's what's coming, and it's certainly, I think, something we all should be aware of, even if we're not doing active work in the EU.
Well, that sounds good, Elliot. Stay safe. We will catch up again next week. Take care.
Yeah, you be well too. Bye-bye.